Hello and welcome to The View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayor Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 182. I hope everyone's been keeping safe and well. Sorry to tell you we have another coronavirus update, but I do promise that I'll get back to doing some non-coronavirus update cases shortly. Anyway, the reason for this podcast is that on Friday, 26th June, the government published its third Treasury Direction. And this, of course, is the legislative provisions governing the coronavirus job retention scheme. And in particular, it looks to implement the flexible working arrangements which are permitted from the 1st of July under the furlough scheme going forward. First point to make is the Treasury Direction is not a happy read. It's really densely drafted. Significant number of defined terms which are defined but they're not capitalised or identified as defined terms, so they don't make any sense when you read them for the first time. The cross-references here, there and everywhere throughout. Well, it's not a terribly long document. It's complicated. The provisions on high water marks, for example, for the number of furloughed employees, I am sure could have been much more clearly drafted. So all in all, it's not an easy read, and my commiserations if you do have to wade your way through it. One point to watch out for when you are reading it is that the Treasury Direction now uses the term flexibly furloughed employee in respect of all employees who are on furlough after the 1st of July. In other words, it no longer differentiates between an employee who is fully furloughed or one who is part working and part furloughed. It's not what I would understand by a flexibly furloughed employee, but anyway, there we go. But it's helpful to read this. Otherwise, like me, you can spend hours going round and round trying to work out what you're missing on the non-flexibly furloughed employees. Anyway, for the most part, the guidance notes which were issued before the direction came out, and they were 12th June, I think, they came out. They do a pretty good job of outlining the new flexible arrangements, but as you would expect, there are a number of points where the third Treasury Direction approaches matters in a way which is not entirely consistent, shall we say, with the guidance notes. And since the direction is the primary legislative vehicle, it's important that employers are aware of these points. So, first up, and it's quite an important point, is the purpose of the scheme. Well, new wording has been added to section 2.2 of the direction, and this now provides, quote, integral to the purposes of the CJRS is that the amounts paid to an employer pursuant to a CJRS claim are used by the employer to continue the employment of employees in respect of whom the CJRS claim is made, whose employment activities have been adversely affected by the coronavirus and coronavirus disease, or the measures taken to prevent or limit its further transmission. So the key points to pick out in that is the monies are to be used, quote, to continue the employment of employees in respect of whom the claim is made. Well, there's been commentary previously, and we participated in that, of course, as to whether employers can use the furlough grant effectively to run down the employee's notice period by keeping the employee on furlough whilst the notice period is operative where they're being dismissed for redundancy. And our view had been that this was permitted under the scheme. And although the new wording is concerning, because how's that consistent with continuing the employment of employees? Although it's concerning at first blush, we don't think the wording actually changes that approach. And I suppose underneath it all, an employee under notice is still continuing in employment. But employers may well find they are criticised if they're making redundancies in respect to employees who are on furlough and for whom they are claiming effectively the notice pay. Because it's at least arguable by HMRC that the employer is not really acting in the spirit of continuing the employment of furloughed staff if they're under notice. But crucially, the guidance note of 19th June entitled "Can my employer make a claim under the coronavirus job retention scheme?" still states explicitly that employers can make employees on furlough redundant. So accordingly, I think what we think is that this is an employee relations or PR point for employers who attract the attentions of the wider world where they're making redundancies, rather than a strict legal point where the employer is disentitled from making the from claiming the furlough monies in respect of employees under notice. So obviously employers need to be sensitive to this issue if that is the step they are taking. Secondly, the employee must actually cease or reduce work to qualify for the scheme. Well, the Treasury Direction explains that an employer can only make a claim for the furlough grant after 1st of July 2020 if it had previously made a qualifying CJRS claim on or before 31 July 2020. A qualifying CJRS claim is defined as being a claim made in accordance with the previous Treasury Direction, which applies to the period prior to 30th June 2020, and it's made in respect, quote, of an employee who ceased all work, whether directly or indirectly, for the employer, brackets, or a person connected with the employer, brackets, for a period of 21 calendar days or more, beginning on or before 10th June 2020. So it's now very clear the test is whether the employee actually did cease work. It's not enough simply to have instructed the employee not to work. And this is echoed in respect to the definition of an employee in respect of whom a furlough claim can be made. In order to make a claim in relation to a particular employee, that employee has to both have been instructed by the employer not to work or not to do their full hours, depending on whether they're fully furloughed or flexibly furloughed. But also, the employee must do no work or must not work their usual hours in relation to the CJRS claim period. To put it another way and put this into some sort of practical sense, if the employer and employee agree that the employee should not do any work during a furlough period, but unknown to the employer and without the employer's approval, the employee does in fact do some work, that will take the employee outside the scope of eligibility for the furlough grant. Former iterations had raised the possibility that it would have been enough if the employer had merely instructed the employee not to work, or the parties had agreed that the employee would do no work. But that door seems to have been firmly closed now. Third point, furloughing sick employees. You may remember that in a previous podcast I talked about the rather odd provisions in the second Treasury Direction relating to employees on statutory sick leave. Well, these had been taken out of the third direction. In the second direction, in essence, what the direction was saying was that individuals on statutory sick leave could not be placed on furlough until their period of sick leave had ended, but only where that ending was agreed with the employee. I thought on balance that meant the employer and employee could agree that the individual would effectively waive their further entitlement to statutory sick pay and move to furlough leave. The original provisions, which were in section 6.3 of the previous direction, have been removed and have not been replaced with any specific provisions relating to employees in receipt of or entitled to receive statutory sick pay. As such, I think the interpretation I was suggesting in the previous podcast is correct, that employees on sick leave can be placed on furlough, but it probably requires their consent to do so because they're waiving their right to statutory sick pay as a condition for moving to furlough. Next up, employer needs to have submitted a furlough claim before, in respect to the period before 1 July 2020, if it wishes to carry on making a claim under the furlough scheme after 1 July 2020. So the ongoing access to the furlough grant scheme is dependent on the employer having previously made a claim under the scheme, or at least having made one by 31 July 2020 in respect of a period prior to 1 July 2020. Whilst one of the guidance notes indicated the employer had to have successfully made a claim before that earlier period in order to be able to claim, the direction merely references the employer having made a claim in respect to the previous period. This is important because inevitably there may be a time lag between making a claim and receiving the money, so it's enough if you've just made the claim. What about employees who can still be furloughed for the first time? Well, we knew that there was going to be a change in this from the previous guidance, from one of the guidance notes that had come out. Basic position, you can't furlough new employees after 10th June 2020. Ignoring things like TUPE transfers for a second, there are two main exceptions. The first of which we knew about, was an individual who is a family leave returner after 10th June can be furloughed for the first time. For these purposes, a family leave returner is anyone coming back from maternity leave, adoption leave, shared parental leave, paternity leave, or parental bereavement leave. One point to watch out for, what happens if someone has a period of unpaid leave after the end of that before they come back to work? Will that take them outside? Probably, but point to watch out for. Anyway, we have a new addition to this category. The new addition is that the employer can also furlough an armed forces reservist employee who's returning to work after 10th June 2020. I confess I have no idea how common an issue that is going to be, but obviously the same logic that said that family returners should not effectively be discriminated against by being unable to go on furlough leave, the same logic applies to armed forces reservist employees. What about consent or legitimate versus legitimate management instruction to being sent on furlough? Well, we have written, as have many others, about the issue of whether the employee's consent to being furloughed is still a live issue. Well, our last update on the guidance notes on 12th of June concluded the position had been clarified. The guidance note that the specific one entitled "Check if you can claim for your employee's wages through the coronavirus job retention scheme" stated, quote, "To be eligible for the grant, employers must have confirmed to their employee or reached collective agreement with the trade union in writing that they have been furloughed. But in relation to flexible furloughing, the guidance note said, quote, if you flexibly furlough employees, then you'll need to agree this with the employee or reach collective agreement with the trade union and keep a new written agreement that confirms the furlough arrangement," unquote. So the guidance note from the 12th of June seemed to be drawing a very clear distinction between flexible furloughing, in the sense that I understand it, i.e. part furlough, part working, and full-time furloughing, where you didn't need consent. Unhelpfully, the direction doesn't take the same approach. And the direction just uses the term, as I say, flexibly furloughed employee to cover all employees who were on furlough after 1 July 2020, so bear that in mind. But secondly, Section 13 defines the agreement that must be in place in order for an employee to be validly furloughed. And Section 13 doesn't make any distinction between employees furloughed for their full hours and in part-time furloughed employees who are part working, part furloughed. Section 13 says, quote, "An agreement is in accordance with this paragraph if the employer and employee have agreed, such agreement may be made by means of a collective agreement between the employer and a trade union, that the employee will do no work in relation to their employment, or the employee will not work the full amount of the employee's usual hours in relation to employment. B, the agreement, including a collective agreement, specifies the main terms and conditions upon which the employee will do no work in relation to their employment, or will not work the full amount of the employee's usual hours in relation to their employment," unquote. The agreement, this section also says that the agreement needs to be incorporated into the employee's contract expressly or implicitly, and it must be made or confirmed in writing by the employer. Fine. So this is all, frankly, rather unhelpful. The guidance note of 12th June clearly indicates there's a different approach for fully furloughed employees and flexibly furloughed employees. The direction, since Section 13 applies to both fully and partly furloughed employees, eradicates that distinction. We still think the employee's consent is not strictly necessary if the contract of employment authorises the instruction to furlough, but the position is a little less clear than it was originally. But on the positive side, you remember that I was struggling with trying to work out why on earth an employee had the right to consent or not to being flexibly furloughed, i.e. part furlough, part working, when the employee did not seem, according to the guidance notes, to have the right to consent to being fully furloughed. There didn't seem to be any logic in that whatsoever. So maybe Section 13, if you're looking for a silver lining, can be used to move full-time employees off full-time furlough back onto part furlough, part working, and the perceived need to get their consent, and what do you do if you don't get that consent, that point drops away in the light of Section 13. The other point to mention is that for the first time, I think, the direction addresses when an agreement must be reached. There must be an agreement in place before the beginning of the period to which the CJRS claim relates, and that's Section 13C. It's expressly stated it's possible to vary an existing agreement during a furlough period. Now, we've certainly had experience of employers who furloughed initially without consent, and then subsequently looking to get that consent in writing retrospectively. And it's important to recognise the guidance on the timing of any agreement to furlough is contained in Part 2 of this, the third Treasury Direction. And as such, this bit only applies to the CJRS in respect of furlough claims for the period after 1 July. Doesn't mean that that sort of retrospective exercise will necessarily have HMRC's blessing, but it's certainly arguable if the provisions about when agreement needs to be obtained have only gone into the direction at this stage, employers may be able to argue that a retrospective consent process is valid in respect of earlier periods of the furlough scheme prior to the 1st of July. Obviously, going forward, employers will want to make sure that there is either a written agreement or they are satisfied they have the authority to put people on furlough fully or flexibly without to avoid running any risks on that process. So those are the points that had occurred to me, at least, coming out of the Treasury Direction, and I hope you found that useful. As I say, I keep promising to do an ordinary podcast, and maybe this time I'll follow through on it. And obviously, in the meantime, I hope everyone stays well and safe and stays alert. And until the next podcast, take care, everyone. Bye.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.